We get asked a lot about adultery. We get asked a lot about this new UCMJ violation of extramarital conduct, what we used to call adultery. So when it came to adultery, the issue really came down to prior, under the old UCMJ article, it was all very heterosexual based. Was there penile to genital contact, actual sexual intercourse, typically between, a male and a female. And that's where the violation lied. They realized pretty quickly that in this modern era that couples look different. And so they have now encompassed more contact between people that's of a sexual nature that can also violate the UCMJ article. So it's no longer called adultery. It's now under Article 134, and it's known as extramarital conduct. The elements of that offense are whether or not there was the actual sexual component between the two. And that comes down to whether or not there was genital to genital sexual intercourse, oral to genital sexual intercourse, anal to genital sexual intercourse, and oral to anal sexual intercourse. Any one of those is going to constitute the physical component for what that would mean as an element that violates the offense. There still remains, just like there was under adultery, this second component, what we call the terminal element. It has to either have had a direct impact on good order and discipline, meaning an actual impact to mission or to the people who serve the mission. And the other way that it can satisfy that terminal element would be to be of a nature to bring discredit upon the armed forces. And that means that it was, if a member of the public were to have learned of all facts and circumstances of this particular affair, would it tend to lower their esteem or how they see the military in their opinion. So it's not just supposed to be just the contact. It has to have this additional component of this, what we call the terminal element. That doesn't keep the military from often trying to curtail or really kind of shortcut that element. Understand that there's some decent military case law that predates this, Nisus versus Roberts, that speaks to proof of the underlying conduct can be sufficient in order to raise an inference that the conduct was also of a nature to bring discredit upon the armed forces. However, that is not the case when it comes to the component of whether or not it was to the prejudice of good order and discipline. In that instance, it actually has to have a direct impact. We usually see that by if the relationship was overlapping and was, dealing with the office, like if the spouse was injured by this affair, the other party, and they couldn't come to work because they were so upset, or they were unable to work with the person who had the affair with their spouse, then that arguably would be able to satisfy that component of whether or not it was to the prejudice of good order and discipline. Of a nature to bring discredit upon the armed forces is a little bit more loose and can be comprised of anything that, the additional facts and circumstances, such as whether or not the person with whom they were having the affair was the military superior of that person. If that caused, other factors to be at play, then you might have that terminal element to be met. Any other questions? Go ahead and try to find us over on TikTok as the Messy Military Lawyer, on Instagram as the same. You can also subscribe to the podcast and check out the blog at www.ucmj-defender.com. Thanks for listening.